Good afternoon and welcome to another Justice for All. This is George Yates. I'm your host today. For the next hour, we'll be here on 1650 AM. And our guest today is Richard Gabriel, who is a trial consultant for more than 25 years. And he's just written a book called Acquittal. And we just passed the 20-year anniversary of the O.J. Simpson trial, and Mr. Gabriel is... that's probably his most high-profile case that he's worked on. He has worked on many of the other high-profile jury trials, criminal trials of the last 30 years. And he is our guest today from Los Angeles. How you doing, Mr. Gabriel?
I'm doing very well, George. How about yourself?
We're doing great. It's a lovely day here in Virginia Beach area. And Mr. Gabriel is on a phone conversation with us from his home in Los Angeles. I read this book, Acquittal. It's required reading for any lawyer. What I was fascinated by, Richard, is the way that I'm an attorney, a trial lawyer, and I read this book, and it read as if you were teaching a CLE class to trial lawyers and how to understand jurors. It didn't speak down. It actually spoke across to me as an attorney.
Well, thank you. I mean, for me, I think there's a lot of things in our justice system and even in our legal education that sometimes reinforces a lot of false notions about really what the jury is and how they go about making decisions in a case. So I wanted, in this book, to not only talk about some of these high-profile cases, but also to kind of peel the curtain back behind the justice system, the criminal justice system, and also about really how jurors go about doing their jobs.
Well, you worked on the O.J. Simpson case 20 years ago, and first of all, was O.J. guilty?
Well, I always have a standard answer to that, which is I don't answer that question. The truth is that the jury found him not guilty. I spend my time focusing on really what is the juror's reality, what is the juror's job. My personal view on the guilt and innocence of my clients is kind of irrelevant, and I've trained myself over the years to pay attention to where I'm getting uncomfortable in terms of what the evidence is showing, but not to necessarily judge my own clients, because once you start judging, whether it's your own clients, whether it's the jury, or even the opposing side, you stop listening. And that's one of the things I found to be most important in what I do, is I have to listen to the jury, I have to listen to the judge, I have to listen to opposing counsel to try and figure out the clearest path in the case towards the decision that you want to give.
Now, you are a trial consultant. You advise attorneys in how to best present their case. And break it down for me. What does a trial consultant do?
Well, a trial consultant works in a lot of different areas, but primarily we work in three separate areas. One has to do with jury research, which is where we conduct focus groups or mock trials or surveys or sort of conduct community or venue studies to really understand the dynamics of a particular community, to understand how individual jurors and their personal makeups, how they view the world. And that's sort of one key area. The second area has to do with really sort of case strategy and communication, in which we help attorneys to essentially formulate, based on the research that we know, a narrative of the case that hopefully will get to the jury's best decision in the case. And that takes the place in terms of sometimes we work with witnesses, sometimes we help develop themes, sometimes we write opening statements and closing arguments, and even examinations. And so that's sort of the communication aspect. And then the third area really has to do with our in-court work, and that's where we actually sometimes sit at counsel table with the attorneys, help them design voir dire questions or jury questionnaires, and help them actually to select the jurors that are going to be sitting on the case, and then monitoring the trial and watching those jurors during the case, finding out where they get confused or where they may have gotten, sort of that negative view of the client and try and give them advice during the trial.
Well, what was it like working with Johnny Cochran, Robert Shapiro, and all those heavy hitters on the O.J. Simpson trial 20 years ago?
Well, it was an amazing experience. I mean, it was, I remember very clearly sitting in a room with not only Johnny Cochran and Robert Shapiro, but with Alan Dershowitz and with F. Lee Bailey and with Henry Lee and Michael Bodden and Barry Scheck and Peter Neufeld, and it was like being in the all-star, Hall of Fame of criminal defense teams, and it was, a lot was sort of made of the divisions among the defense team, but the truth was that everybody really was focused on the ultimate result, which was, getting a good result for the client. But it was an amazing experience.
What are some myths about the O.J. Simpson trial that your book dispels?
Well, the first myth that I really wanted to dispel is this notion that somehow if they had tried the case in Santa Monica, that they would have had a different outcome. And the truth is that in Los Angeles, we have to gather a random pool from a 20-mile radius of wherever that courthouse is. Now, 20 miles from Santa Monica still has South L.A., Inglewood, East L.A., has a lot of different areas which has that lower socioeconomic jurors in it, has a lot of African Americans in it, and we were very focused on wherever the DA was going to try the case to make sure that there was a representative sample, representative cross-section of the community from all these different areas. The thing I dislike about that myth is that it basically says, look, if white affluent people had tried this case, he would have been found guilty. And I think that there's a little bit of a racist undertone to that assumption, which I find a little offensive. The second myth, has to do with really, which are a couple of some of our research found in doing the trial, which was that, the biggest myth of all is that race was the determining factor in this case. And I'm not going to deny that race was a factor, but the truth was that when we picked that jury, 9 of the 12 jurors had had negative police experience. They themselves or family members or friends had been pulled over. In Los Angeles, we call it a DWB, driving while black, had had stuff planted on them, had been harassed, had been just, unreasonably hassled by the police. And so that was our key element that we were looking for in the case, people who would be receptive to the arguments.
So it appeared that race was a factor, but it was more the factor in the sense that you had black jurors who had been treated differently by the L.A. Police Department than perhaps a white juror might have been treated. So they felt that they basically just did not trust the Los Angeles Police Department and boiled down to a credibility case.
And that was the huge issue. We knew that there were some really questionable practices that Furman, Van Adder, and Lang had sort of undertaken with the evidence. So we wanted a juror that would be receptive to arguments that, hey, the police do plan things. They do misdirect. They do sometimes misrepresent to the judge that there is exigent circumstances when there really is none. In order to get a warrant and go into Rockingham. And, a lot of upper middle class, white affluent jurors, they take a look at the police and, I grew up in Santa Monica, so I was the same way. I'm like, police wouldn't do that. But our population, the jurors that we selected in this case, were like, okay, I believe that. I believe the police would do things like that.
We are here with Richard Gabriel. He is the author of Acquittal, his new book. It just came out in June, and it's an incredible overview of not just the O.J. Simpson trial, but the Casey Anthony trial, the Phil Spector trial. Throughout this book, Richard Gabriel discusses some of these high-profile criminal trials that he's worked on over the years. I'd like to get back to the O.J. Simpson trial in a minute, but you don't just work for criminal defense. You work for the prosecutor as well over the years, as well as you do civil and criminal cases, correct?
Absolutely. We, in the criminal realm, we've done more work for criminal defense, but I've worked for the Department of Justice, I've worked for DAs, I've worked for a number of prosecutors in bringing their cases, and quite frankly, a lot of our work is in the civil arena as well.
The fascinating thing about the O.J. Simpson trial was also the myth that O.J. bought his freedom because he paid so much money for his attorneys. What does your book say about that?
Well, no doubt that O.J. Simpson had a lot of, hugely much greater resources than any average defendant in a criminal case. And he absolutely could afford some very good attorneys. But the truth is the district attorney's office had an unlimited budget in this case. And they spent, I would estimate, 2 to 3 times more than O.J. Simpson did. They had the FBI laboratories at Quantico available to them. They had unlimited investigators. They had unlimited detectives and experts working for them on this case. And, the myth that is perpetrated in a lot of these cases is that, these wealthy defendants just get off because they have a lot of money. And that money is matched, if not considerably overwhelmed by the resources in a district attorney's office.
The other cases that you've worked on, when you talk about money, how is it then that your average defendant, the ones who don't have the deep pockets of an O.J. Simpson, how do they match up? How do they defend themselves?
Well, it's gotten very difficult for any criminal defendant these days, and it doesn't have to do just with resources. There are some political pressures at work here. In California alone, because what happens is that legislatures pass laws, and those laws sometimes have taken place in terms of either 3 strikes laws or mandatory minimum sentences, and the difficulty, capital cases are another really good example of this. In California alone, there are, I believe, 34 special circumstances that qualify a defendant for the death penalty, one of which is sort of a lying in wait, which makes it kind of virtually indistinguishable from just a murder 1 charge. So it doesn't mean that they keep bringing capital cases, but it means that for a criminal defendant, if they're being accused of a murder, the district attorney can put the capital count on the table and say, you better take a plea deal, or we're going to charge you with a capital count. And it just creates greater leverage. So all these mandatory minimums and all these extra sentencing guidelines and all of these sort of difficulty, let alone sort of the public's attitude, has gotten very strict on crime. And so it's made it very difficult for an average defendant in any criminal case.
But you do occasionally offer your services pro bono.
Oh, absolutely. I mean, I've done work on either greatly reduced fees for public defenders' offices or just offer pro bono services. In the Casey Anthony case, I worked for 2.5 years on that case pro bono. I didn't get paid at all. Well,
that's justice for all. Thank you, Richard. Now, one of the fascinating things about another myth about the O.J. Simpson case was that in the opinion of the jurors after the verdict, was they gave you the opinion that the DA's office had actually played the race card first. Tell us about that.
Well, it was very interesting because, and again, I spend my time listening to what jurors say, not to necessarily what the pundits say. And the truth is that the jurors, Marcia Clark was the lead prosecutor in this case, and she was originally trying the case with Bill Hodgman. And Bill Hodgman had an illness that he had to sort of withdraw from the main part of the case, and they brought in Chris Darden. And so the jurors saw this, and obviously he was brought in before the case started, but the jurors read the news, and they thought that just by bringing Darden in, that they were playing the race card and appealing to an African-American jury. The truth is that both Chris and Marcia were very experienced district attorneys, and they had done lots of cases downtown in front of largely African-American jurors, and they felt that, gee whiz, I have this mountain of evidence here, how can I lose this case? But they miscalculated on a number of strategic fronts and thematic fronts in trying the case.
The O.J. Simpson verdict and the Casey Anthony verdict are both examples, and you talk about that in your book, of where the public had one verdict and the jury had another verdict. I'd like you to talk about that just a minute.
Yeah, I mean, I call this the constitutional clash of ideals because, the truth is that in these cases, we now have these highly sensationalized cases where the First Amendment rights of the public to know what's going on in any given case can't be infringed, and the judges allow the press full reign. What happens, though, is it creates two separate juries, a jury at home and a jury in the box. The jury at home basically has no rules. We can speculate about anything. We can look up on the Internet anything about the defendants and their past histories. We can consider evidence that will never come into court, and we can judge that defendant prior to the case being called. A jury is sitting across the courtroom, and they're looking at that person, knowing that their decision is going to determine their fate. They're charged with keeping an open mind. They can't discuss the case amongst themselves. They can't consider this extraneous evidence. And jurors do a phenomenal job of trying to abide by those rules. But it creates this disparity where, at home it gets fueled by pundits and experts that sort of opine on this stuff. And it makes it very challenging also for a defendant to truly have what we call an impartial jury. In other words, a jury that basically isn't tainted by what they've previously heard about the case. When
I read your book, the very first thing that jumps out at you is that this fellow Furman jumps over the wall at O.J. Simpson's house and tells the jury with a straight face that he jumped over the wall because he thought that there might be a need to render emergency service. When in fact the jury listened to that and they didn't believe that, and they never believed another word he said after that, did they?
No, not really. And this is where I think sometimes all attorneys, but in that particular case, the district attorneys really misjudged, how jurors looked at this. And there are these small inconsistencies which can create huge credibility problems. In this particular case, they said, well, I was, Furman said that, we got this warrant. I was able to go over the wall. We exigent circumstances. I really thought somebody, and yet the jurors were like, well, wait a minute. You jump over the wall there. You think someone's hurt. Nobody's guns are drawn. There's no other sort of alarms. You're not calling for backup at the time. So there were these inconsistencies which to jurors went, you know what, you lose credibility. And as you know, George, the jury instructions are if they're not credible in a part of their testimony, the jury can judge that their entire testimony can be dismissed.
And Lieutenant Van Natter took a blood sample and took it home with him?
He didn't take it home with him, but what happened is they took a blood sample from Bundy, and instead of driving it right down to Parker Center downtown, he carried it around with him all day.
And then didn't properly put it into evidence for a couple of days?
I think it was later that day when they finally booked it into evidence. But the truth is that also from when he first took the measurement to when they finally booked it into evidence, there was like 0.8 milliliters difference of where some blood was missing. And so, again, the jurors went, well, wait a minute, you're carrying it around, there's some missing blood here. What's going on? And then all of a sudden, there's little other inconsistencies, like there's a sock in O.J. Simpson's room at Rockingham which the original investigators do not see at the foot of his bed. And then later on, they find that's booked into evidence a little bit later in the day. So the first view, they don't have this, and lo and behold, there's Nicole Simpson's blood on that sock. And they find, like 2 weeks later, some extra blood on a gate at Bundy that they hadn't previously found. So all of a sudden, jurors start seeing these little pieces that start not adding up for them on the prosecution side and start creating another picture in terms of an explanation for what happened here.
And when you have jurors that already have negative police experiences and already have predisposed opinions that the police can plant evidence, you're going to end up with an acquittal when you have problems like that in the evidence.
Yeah, I mean, the truth is that another big strategic mistake, not only in terms of the jurors' experiences, but the prosecution evaluated this case and they went, well, we've got all this tremendous evidence, and they thought they would be a good idea to put it all on display. So they thought that the more they put into evidence, the greater the weight that they would have and the greater chance. But the problem is that what ended up happening is they created their own reasonable doubt. Because when you have Dennis Fung on the stand, sitting there talking about the DNA evidence, and you have very skillful attorneys like Barry Scheck and Peter Neufeld cross-examining him, all of a sudden the length of time of the presentation starts creating question marks for the jury. And so this is where I think they miscalculated. If they had tried this more as a routine double homicide, 2-3 weeks, I think they might have had a better chance.
Our guest is Richard Gabriel, the author of Acquittal, who was trial consultant to O.J. Simpson. You discuss in your book, in general terms, there are 4 different kinds of justice. The word justice, that's the name of our show, Justice for All. You describe 4 different definitions of justice in the American legal system. What are they?
Well, I find that we have this very pure but somewhat naive view of really what justice is. And for me, in my years in doing this, I've found that there are 4 systems. The first system is what I call capital J justice. And it's the kind of justice that we get in Supreme Court rulings, it's taught in law schools, it's passed by legislatures across the country, it's influenced, obviously, by politics and legislation. And what we find is that that creates what I call the big rule book by which we all have to play. It creates laws. The next system that I call is called lowercase justice, which is a place where you and all the attorneys and judges and court clerks practice. And it is essentially the mechanism. It's the mechanical mechanism behind the justice system. It takes place in pleadings, it takes place in jury selection and in trials, and it's where all the hard work and effort and years of poring over case evidence occurs. The third justice system I call headline justice, in which we see it on CNN and we see it even in hour-long primetime shows like The Good Wife, Law and Order, and CSI. And it's more of an idealized version. It's sometimes a sensationalized version in these big cases. And sometimes it creates a lot of misassumptions about really what the justice system is. And the final one is what I call jury justice, which is really how jurors ultimately make decisions in the case. It has to do with how they parse through evidence and combined with their own personal experiences, their attitudes, their beliefs, ultimately come up with their story of the case and the decision on what happens.
We're going to take a short break here. We're with Richard Gabriel, the author of Acquittal. When we get back, Richard, I'd like to talk about the Casey Anthony trial, which is the most recent one that you've worked on, and we'll be right back after a short break.
I don't like Car Care is your place for all of your automotive needs. They handle state inspections, brakes, tune-ups, oil changes, transmission service, radiator repair. They have a wide variety of tires, and when it comes to your car, they do it all. Visit their two locations at 2711 Victory Boulevard in Portsmouth and 2236 South Military Highway in Chesapeake. For more, log on to thinkscarcare.com and call 545-3573.
Your family and their safety are your number one priority. Your homestead and your business and quality of life can give you peace of mind, but there are some bad hombres out there. Keep it all safe with the proper firearms and ammo from Battlefield Guns and Ammo. You can't take anything for granted, whether you're at the ranch or out on the trail. Call 757-410-7720. Log on to battlefield-guns.com and visit Battlefield Guns and Ammo at 240 North Battlefield Boulevard in Chesapeake.
Excellent Italian food is found at Spaghetti Eddie's, a neighborhood restaurant with a great family atmosphere and delicious Italian cuisine. Define Spaghetti Eddie's. New York-style pizza, pasta, subs, calzones, soups, salads will bring you back again and again. Log on to SpaghettiEddiesPizzaCafe.com and visit them at Greenbrier and Western Branch. Quality Italian food is at Spaghetti Eddie's.
You are out of order! You're out of order! You're out of order! The whole trial is out of order! They're out of order!
We're back with Richard Gabriel, the author of Acquittal. This is Justice for All. I'm George Yates, your host. This book, Acquittal, was just a really fast, exciting read for me. I'm an attorney, but I don't think you have to be an attorney to enjoy it, because all these trials that Richard Gabriel writes about in this book are the sexy ones, the ones that were on TV a lot, that Nancy Grace covered, that were on court TV, CNN, MSNBC. Richard's been on countless shows as an interviewee, I should say. Just to give you a list, folks out there that are listening to this show, these are the stories that he covers. Of course, the O.J. Simpson trial, the Heidi Fleiss trial, the very high-profile madam from Los Angeles. United States versus Jim Guy Tucker. This was all involving the Whitewater. Those of you who remember Whitewater, Bill and Hillary Clinton, the whole politics of that. United States versus Rex Shelby. That's a very fascinating case, really, about the internet. And maybe Richard can talk about that one just a little bit. Of course, the people of the state of California versus Phil Spector, the great music producer. And then most recently, Casey Anthony. I'd like to go backwards from Casey Anthony, Richard. Your chapter says two verdicts, one public and one private. Tell us about the Casey Anthony trial, your work on it, and your view on that trial.
Well, Jose Baez called me about 6 months into the case when he had it. And he'd heard about me, and he called me and he said, look, I'm just getting killed in the press about this thing. It's just, Nancy Grace had already done like 100 shows on it. She coined the term tot mom, and the pitchforks were out. And for the most part, the public had already decided. And I describe in the chapter a little bit about why, because not only had it been in the news a lot, but Orlando, and to a certain extent, this was publicized in the whole country, there was a time where Kaylee was missing, and the body hadn't been discovered yet of the child. And so people, there's a point, I've got kids, and there's a point where you feel emotional whenever you hear about a missing child. And I think the public got so invested in finding this child, and then when they found out that she was dead, and then when they found out that Casey Anthony had lied so significantly and had been out partying for 31 days while her child was missing, and then ultimately was dead, that's so conflicted with how they thought about how a mother would act that they had already said, well, then of course she did it. Of course she had murdered her own child in order to be free. And this kept going. The momentum on this was just really quite extraordinary. So Jose said, I just don't know how I'm going to get a fair and impartial jury in this case. And I basically told him, you're not. it's been so poisoned, the whole state, and to a certain extent the country, have been so poisoned with this negative publicity that I said, we have to develop another strategy. I told him he couldn't fight it. He couldn't get up there and make statements or create some sort of media campaign to try and resurrect, this her image or anything resembling, sort of a let's be fair type of scenario. So I said, look, we need, and I started seeing this in the O.J. case, we need to use this to our advantage. In other words, we need to almost further the momentum so that it's so, at such a high fever pitch, the emotional tenor of the trial, that it's apparent to the media and to the public and ultimately to the jurors that they really weren't being fair to her. And it got to the point where even CBS called me and said, look, we've seen a tremendous amount on this case, and it just seems to be really loading the deck here. We would like to do something a little bit from the other side. And I asked them if they wanted to film a focus group. Since I was working pro bono, Casey Anthony couldn't afford anything like that. So they funded a focus group in which we talked to Orlando residents about how they felt about the case. And I sat down with this group of people, and I said, well, what do you think? You've heard a lot about this case. And they said, well, she's guilty, of course. And I went, really? And so what do you think about the media coverage? And they went, oh, it's been terrible. It's been way overblown. And I said, do you think she can get a fair trial? And they said, oh, no, of course not. She can't get a fair trial here. And then I said, well, okay, let me walk you through the evidence. And in Florida, there's this thing called the Sunshine Statute, which basically makes every document that is exchanged between the prosecution and the defense a public record. So they'd all seen it, but I said, let me walk you through all the evidence in the case. We, of course, didn't present any of the defense strategies, but I walked them through what we pretty much knew the prosecution was going to do, asking some questions along the way. And a very interesting thing happened, because at the end when I said to them, okay, now that you've heard everything, which of you would convict her of first-degree murder? And only 3 people raised their hand. And you could hear the collective jaws drop of CBS and even Jose in the other room. And I said, well, wait, why? You said you thought she was guilty at the beginning of our session. And they said, something doesn't make sense. Something doesn't add up here. And we spent a lot of time talking to them, really, about what were the holes and in the forensic evidence and why there was no DNA on the tape that was around Kaylee's mouth, and why the forensic evidence in the car didn't make sense, and why even the motive evidence didn't make sense, because Casey had this built-in babysitting service with her mom and her dad, so she didn't need to be free of her child. So at the end of that, I said, well, what do you think happened? And they said, we think the child drowned. And we think that she was so ashamed, and because the psychological dynamic in this family is just off for whatever reason, we think something strange happened here. She's so ashamed she would never admit it. And it was just unbelievable, because it's ultimately what the jury came up with in the real case.
So there were just too many mysteries that were never explained.
Were never explained, and inconsistencies. And they, when jurors are charged, this is why I have such faith in jurors, is when they were charged to really look at it, they went, wait, I'm not just sitting around speculating about what I think happened or why I think she's a bad person, but they said, look, if they're going to say that this is a death penalty case and that, she intentionally killed her child to be free of her, then even though prosecutors are not required to prove motive, but you had better tell me why she intentionally placed that duct tape around that child's mouth, especially when most of the prosecution witnesses have talked about, even though that she's partying during the 31 days, about how she loved her child so much, and there's not a single piece of evidence to say, oh my God, this kid's such a burden, I wish I could be free of her. So these little inconsistencies made it difficult for them to really match it up. And I think we're counting on this just deep emotional pull and outrage to convict her.
And this was a death penalty case, wasn't it?
It was a death penalty case. And, this is where, again, the prosecutors, I think, miscalculated. Because even though they had the lesser includeds of, I think, a second degree and even an aggravated child neglect charge, which in Florida, by the way, carries a mandatory 30-year term, they tried it as a death penalty case. So that's where jurors saw it as that. And even though it doesn't carry a higher burden, jurors, if they take a look at a young woman sitting there and saying, I'm going to ultimately have to sentence her to death, they think that the proof and the level of proof has to be pretty high.
So in the Anthony case, did they death qualify that jury?
They did death qualify the jury. And one of the things that was, I think, quite surprising about in that case, and to tell you the truth, Florida is for any criminal defense lawyer, is a very difficult place to try a death penalty case because a simple majority in the penalty phase can levy the death penalty. You don't have to have unanimity in the jury.
Crazy.
So that by itself is crazy and really ridiculously tough for a criminal defense lawyer. But I'll tell you, when they were voir direing the jurors, one of the things that occurred to me, and this is a little bit unusual, we had a lot of jurors in that phase who said, in principle, I don't like the death penalty, but I can do it. And George, for you've probably done some death penalty cases, but typically what you get is a lot of jurors who say, I can't do it. I just am morally opposed to the death penalty, and they're all excused.
Right.
You get a lot of people who say, I believe in the death penalty for all first-degree murders, but I can consider the facts. And those jurors are usually seated, which is really a problem. But you don't get a lot of people who say, in principle, I'm kind of against the death penalty, but I can do it in this case. So we had some of those jurors, which was unusual and really great. We ultimately ended up with a very good mix of jurors.
Well, now, ultimately, you did get the venue changed from Orlando to where did you switch the venue to in that trial?
It was in Tampa, Pinellas County, and that was another sort of strange thing in that case, which is that in Florida, some other states do it too, they import juries in high-profile cases. So instead of a full change of venue where you go to another city or county and try the case, you go and pick a jury in that county, and then you bring them back to Orlando, sequester them, and they hear the trial there. The challenge for us is that the judge wouldn't tell us where we were going to pick a jury. So we didn't know until Jose knew a couple days before, but he couldn't even tell anybody. So for the most part, nobody knew until the day of the jury selection where the judge was going to go and pick a jury. And then it was a scramble to get there. Ultimately, I couldn't do it because I was working pro bono and because just the circumstances. It was really challenging because, my belief was, look, it was deemed that Orlando couldn't be fair to it, but I believe that we should be able to go to wherever we went, whether it be Jacksonville or Miami, and study that venue and see if they could be fair. Luckily, we ended up in Tampa, and they actually ended up with really good jurors there. But it was a really unusual situation.
This Casey Anthony trial is fascinating, but you basically, the jury, even though they hated Casey Anthony probably because of what she'd done during those 31 days, they were swayed by the lack of forensic evidence linking her to the murder.
Yes, and this is where...
And the mysteries surrounding the case. And the reason I'm mentioning that is because you have another high-profile trial you worked on, maybe not quite as sexy as the as Anthony, but the Phil Spector case, the famous Wall of Sound music producer, who was charged with murdering his girlfriend in what was an apparent suicide, and in that case, you did a lot of research on that and determined that the forensics actually favored Phil Spector. And tell us about that case and how your jury research really influenced how the defense tried that case.
Well, we knew that there was obviously big problems in the case because it's his gun, and here's a woman who's dead in his house, and there's a limousine driver who testifies that Philip comes out of the house saying, "I think I killed somebody." And so for most people, and, in California we have this evidence called 1101B, which is past incidents which are not supposed to be used for character, but are always used for character. And the judge was going to let in 4 women who would say that Phil Spector pulled a gun on them. So we knew that all this character stuff was really bad and would obviously tend to point to his guilt. And, even just people would come up to me and go, well, just look at the guy.
How did they get that in? Is that 404B evidence under the federal rules? Would that be to show motive, opportunity, common scheme? Is that the classic 404B evidence that the rest of us know about?
404B, yes. It's 1101B in California statutes, but yes, in federal statutes, it is that same thing. And they say, this isn't to show character in it, but how are jurors going to not use it to show character evidence? And so, but the crazy thing was that when we looked at it, Robert Blazer, I worked with on the Simpson case originally, sort of helped this, and I met Linda Kenny Bodden, who is one of the premier forensic criminal defense lawyers in the country, and she really took the lead in this case on the forensics part. And we did this research, and we basically said, look, should we try this more as a character case and saying, Phil Spector is this great man, and he really wouldn't do some things, and despite, these prior women, he didn't do it in this case, or should we concentrate on the science? And our research really showed that, we didn't do so well when it was just about character, but when jurors really dug into the forensics, they really saw how, she was holding the gun at the time it went off.
And the jury, was it an acquittal, or wasn't it a hung jury?
It was a hung jury originally, and it was a very difficult. Originally, it was a 7-5 hang, which is, as you know, George, a very good result for the defendant, because it really, if it's 1 or 2 jurors, sometimes the prosecutors can sit there and go, oh, well, these are outliers, and I'm going to retry. But when you have a really big split, they have to rethink whether they're going to retry the defendant on the charges. And
but they did. They did try him.
And they did retry him, yes. And the problem is that the judge stepped in when it was a 7-5 split, and he re-instructed and gave various scenarios under which they could find him guilty. And the jury went back, and they still were hung, but then it became a 10-2 split. And so they ended up retrying him, and he was ultimately convicted.
And
next time around.
The 10-2 split gave the government a little more incentive to try it again. They thought, well, if we can get to 10-2, we might be able to convict him the next time around. We'll have a better case. Yeah, and as you well know, when you retry a case, the prosecution, rethinks its strategy. They know a little bit where the defense is going, so it's much easier to get a conviction the second time around. Yeah, I like those 6-6 splits. They generally will drop them. They won't come back again if it's 50-50. Yeah. So, Phil, and you worked on the first trial. You did not work on the retrial of the... Oh, no, I worked on the second trial, too. Oh, you did? I did. It was difficult because the prosecution knew where we were going on this, and so we had less of a surprise factor in terms of going after it. It was tough because the judge
who sat on the original trial, we felt he was really giving some very unfavorable rulings to us and was really sort of pushing the jury in a particular direction. And that, became harder in the second trial to do it. And ultimately, the jury, and the thing that I had difficulty with is the jury in the second trial came back and they said afterwards, well, we really believe that the prosecution's version of what happened was more likely than the defense's version.
Another preponderance instead of guilt beyond a reasonable doubt.
Exactly.
Well, I was fascinated by the fact that it looked clearly like a suicide, and not too many people commit murder if you're shooting somebody through the mouth. We only have about 10 minutes left. I wish I had a whole other hour to talk with Richard Gabriel about his book, Acquittal, in these many cases. I wanted to perhaps spend the last few minutes talking about this fascinating, it's not as sexy of a trial, not that many people have heard about it, but this Enron case that you are involved in. A lot of people know about the collapse of Enron, but they don't often know about the case against Rex Shelby, and how a lot of this, apparently this prosecution delayed some of the most important technology that we're using today. Tell us briefly in the next few minutes, Richard, about this, the Rex Shelby case.
Well, Enron developed at the same time. They were looking to expand, and so they took their oil and natural gas network and said, hey, how can we capitalize on basically this network idea? Skilling at the time, really having worked for McKinsey and Company, really was on the lookout for other revenue streams and said, look, a computer network could be just like a oil network, and if we can develop that. And they bought a company called Modulus, which was in Oregon, and with the idea of basically developing this technology in a platform. And Rex Shelby was one of the engineers, just a really straight-up guy, really straight shooter, great guy, who just loved technology. And he had developed these things that we now use today, which is basically an infrastructure for the cloud and for applications that we use on all our phones. And you have to remember, this was before any of this was really developed.
What year are we talking about?
This is in the sort of the 1998 to 2001 period of time.
So 10 years before its time, or
exactly. More. And so they were developing this and looking at streaming things at the time. The ability of broadband to stream live events and videos, which now are all over the place, really was very difficult. So they developed this structure in which they had servers and things in which to create this broadband with and be able to do it, and they were going to capitalize on that. And the misconception, I think what happened, is that when Enron fell as a result of a lot of other structures in place, financial structures and things, and then this was right on the heels of the September 11th attacks. And one of the things I talk about in the book is that I believe that we were shaken by the attacks in New York and at the Pentagon to the extent that we started questioning our military might. And then all of a sudden, the seventh largest company in the United States falls. And our Justice Department said that there's no way that this could have happened without there being some sort of fraud here. And they put a gang prosecutor, John Kroger, on the case. And when you're a gang prosecutor, you prosecute a criminal organization. And he viewed Enron ultimately as a criminal organization where everybody was in on it. They wanted to use Rex Shelby and the Enron broadband folks to get to skilling, and so they tried to leverage plea deals, but the truth is none of these guys thought they'd done anything wrong, so they refused plea deals. And so they had to go ahead and try them. And with basically the concept that this technology never worked, and you were just lying about it to the investment advisors when you said it did work. The problem is that in the bankruptcy, the DOJ allowed all of the technology to be sold off. And so in trial, we couldn't present it and say, here it is, here's how it works. And so it was really challenging because of all the, obviously, negative publicity, and Houston was devastated by the fall of Enron. And so it was challenging for us to pick a jury in the case and toward convincing them that, maybe it didn't work to the idealized extent that the government thought it should work, but the technology did work. And that technology, as we know, is constantly evolving. It's not like a light switch where it either works or it doesn't work.
Now, Rex Shelby, did he ultimately get convicted of anything?
No. As a matter of fact, all of the defendants in that trial, there were no convictions. There were, because there was tons of charges, there were a lot of acquittals and also a lot of hung jury charges. And a number of people ultimately went up to the Supreme Court on some of the, I think it was on Yeager, and the Supreme Court said, look, it basically dismissed a lot of the charges against him, but Rex ultimately was faced with another DOJ prosecutor who admitted to them, if it was today, I probably wouldn't have brought this case. But he couldn't. After a while, he couldn't fight it. He did no time at all, but he pled to a couple of lesser counts, and it was over with. But it was a shame because he really did nothing wrong.
Eventually, the federal government, if they go after you long enough, I had a guest last week, the original NSA whistleblower, if they keep going after you long enough, they wear you down, and then they'll finally say, you have to plead to something. So you'll plead to a misdemeanor, no time, just to get out of it so they can say they had a win. That's what it looked like against Richard Shelby. And it seemed to me that, did you try that case down in Houston? Is that where it was?
That was in Houston. We did a bunch of surveys to show that that the community was really predisposed against the defendants, but the judge kept it there. We had to pick a jury down there, and we ended up, again, getting a decent jury who said, look, we don't think, they thought, some of them, it was a 6-6 split on the acquittal charge, on the hung jury charges, and then a lot of acquittals in there, too.
Is it fair to say, I mean, I get this, that had the Enron been prosecuted a little bit differently, and had they not gone after Shelby, that this technology, that this cloud technology would have been available to the public years earlier?
Well, that's one of the conclusions I make in the book. I don't know for sure, but the truth is that Rex is a really brilliant guy, and all the guys that were working at that company were really dedicated, and we're bringing a technology that was a lot of people were working on, but they really had a big step on. And I think we would have had some of this stuff sooner.
We've only got a couple of minutes left. Richard Gabriel is here with his book, Acquittal. Anything, what are you working on now, Richard, that's interesting to our listeners?
Well, right now there's a number of cases. Quite frankly, a lot of, although I write about a lot of the high-profile cases, a lot of the cases I work on are more bread and butter, and they're civil cases, and sometimes they seem mundane. I find them all interesting, but they can be product liability cases or employment cases, and so there's just a variety that I'm currently working on.
And I've got a jury trial beginning on Monday over in Hampton, so I think after we get off the air here, I'm going to call you back so you can give me a little pointers on how I should go about selecting that jury.
Yeah, no problem.
Listen, thank you very much for being with us today, Richard.
It's been my pleasure, George. I appreciate talking to you.
All right, thank you. This is another edition of Justice for All. I'm your host, George Yates. I'd like to thank my producer here, my engineer here, D. Thomas, and my producer, Greg Hall. We'll be back next Saturday from 2 to 3 here on 1650 AM. So you have a great day. You enjoy that beautiful sunny day out there. Head on down to the beach, and we look forward to have you come by and listen to us again next week. Thank you.